My name is Vinesh Rohi. My registration number is 2139472. Now, I will present my second case study. Union of India versus K.A. NAJEEB 2021. Facts. A professor T.J. Joseph, while framing a question for his students, included a question which was objectionable to certain sections of the society. So, the respondent in this case, K.A. Najib, along with the members of Popular Front of India (PFI), tried to attack the said professor in order to avenge this act of profanity. So, the group attacked the professor when he was returning home. They attacked the victim's car and critically hurt his palm with a small axe. They also hurled bombs at the public to create panic and cause confusion. As a consequence, an FIR was filed with the victim's wife under multiple sections of Indian Penal Code and Section 3 of Explosive Substances Act. After some time, it was found out that the attack was a part of larger conspiracy which was much more serious. Hence, various provisions of Unlawful Activities Act UAPA were invoked against him. Now, the respondent was arrested by the NIA and was put in judicial custody for a span of 5 years without being tried by any court. He approached the court for at least 6 times, but his pleas were rejected because his actions, which were knowledge about the attack and his assistant, made him an accuser under Unlawful Activities Act, and by the virtue of Section 43D of the said Act, normal bail rules could not be applied to him. Legal issues of the case. The main issue was whether a violation of Article 21 can surpass a strict statutory law such as Section 43D of UAPA rules. The following provisions were invoked in the case. Section 43D of Unlawful Activities Prevention Act. Section 43D reads, notwithstanding any content in the code, no person accused of an offence punishable under chapters 4 and 6 of this act shall, if in custody, be released on bail or on his own bond unless the public prosecutor has been given an opportunity of being heard on the application for such release, provided that such accused person shall not be released on bail or on his own bond if the court, on a pursuit of the case diary or report made under Section 173 of the Code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Article 21 of Constitution of India. Protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedures established by law. Analysis. The Unlawful Activities Prevention Act is primarily an anti-terror law aimed to give state the power to deal with cases involving activities which might harm the sovereignty and integrity of entire nation. The act has death penalty and life imprisonment as a part of the punishment. This act was brought in 1967 and it gave the center the power to ban any association which might harm societal harmony. In 2019, the government made certain changes to the law by widening the scope of certain definitions and thereby opening it to misuse. The law has now become a tool to resist fundamental rights of the citizens, and what such incident were abuse of power through one of the provisions of this act is observed in this case. The court here gave a situation when a bail can be cancelled and stated that there is a distinction between the parameters which are taken into account while considering a bail plea and those applied in cases of its cancellation. It further stated that the bail once granted by trial court will only be cancelled by the same court in cases where a new situation takes place. And if this does not take place, then one can approach to a higher court exercising appellant jurisdiction. The High Court in this case, in line with the judgment given by the lower court, decided that the bill is to be granted to the respondent. The main issue which was dealt by the court was not whether the acts of the respondent fall under the provisions of UAPA, but rather it exercised its power to grant bail in a case where a long period of incarceration has happened and this is a low possibility of trial happening anytime soon. The reason here given by the court actually root from Article 21 of the Constitution, as the court in the case Shaheen Welfare Association versus Union of India have mentioned that a delay in disposal of such cases invoke Article 21 of the Constitution, which makes it necessary to release the person on bail. The court considered various factors before giving this judgment of granting bail to the respondent, which include that the respondent has already been in jail for more than 5 years, the NIA has not shown any inclination to screen the list of witnesses which were present, and the most important reason was that there are 276 witnesses which were left to be examined which implied that a considerable amount of time is still left for the respondent's trial. Conclusion of the case. Even though the charges against the respondent are of a serious nature and pose a potential threat to the society, the time spent by the respondent in custody and the unlikely scenario of the trial being completed anytime soon could not be overlooked. This caused the courts to grant bail to him, as any further custody would be infringing upon his fundamental rights, which is his right to life. Through this case, the court also attempted to strike a balance between the appellant's rights to establish charges and the respondent's rights guaranteed under Part 3 of the Constitution. A charge under UAPA makes it difficult for people to get bail due to its restrict provisions pertaining to bail and widened definitions. What this case has done can be observed as a ray of hope for several people who have been accused under this act. Thank you.